Good morning, everybody, and a very, very warm welcome to you. I love seeing so many people jumping into the session, bright-eyed, bushy-tailed, and nice and early this morning. We are going to probably get started with the formal side of things within the next 15 minutes or so. I'm going to do welcomes and just some housekeeping while we wait for the for everybody else to join us. Right, for those of you who have not met me before, my name is Mervyn Vermeulen. I'm going to be taking you through the program this morning together with our esteemed speakers today, and we look forward to talking to you about reframing mediation from obligation to advantage, understanding the benefits of mediation under the Gauteng Protocol. We've got a very, very interesting lineup of topics for you this morning, and I hope that you will find immense value from this morning's session. Folks, regrettably, AI note takers are not permitted in this morning's session. It is a free to watch session. Unfortunately, however, we have had a heck of a lot of problems with plagiarism, piracy, and all the rest. So I am going through and I am removing the AI note takers from the meeting. However, do not fret. You will have the opportunity, if you need to pop out for whatever reason, the session will be recorded and we will make it available on YouTube for everybody to watch. If you use AI at that stage to make notes, then that is on your conscience. But unfortunately, for today's purposes, we are not allowing artificial intelligence note takers in the room. If you do have an AI note taker, I would request that you please disable it now, although we will be going through and removing them as the session goes on. So for those of you who joined us for the first time today in a ThinkLegal webinar, I would like to introduce you to ThinkLegal. Legal knowledge open to everyone. We champion the open sharing of reliable legal knowledge. In the spirit, we foster professional dialogue and knowledge exchange through vibrant WhatsApp groups. I think vibrant is a very diplomatic term for the vast amount of information kind of shared on the WhatsApp groups, and insightful webinars and network events, which we'll tell you a little bit about later. We do free training sessions as well as paid training sessions from time to time. For more information, please go to thinklegal.co.za. There you can register for events, you can join our WhatsApp groups, you can purchase resources, and you can view our past webinars. So please do pop through to thinklegal.co.za. If you are not yet a part of one of our WhatsApp groups, where are you? Why are you not part of the conversation? Go to thinklegal.co.za. You'll see there is a tab for WhatsApp groups. We have a commercial litigation and labor law WhatsApp group, a family law WhatsApp group, and the events notifications WhatsApp group. Also, part of this bigger ecosystem is the mediators support circle group, which is administrated by my friend Ordinary Lowe, which is a place for mediators to debrief, share information, and so forth. So please do feel free to get involved with those initiatives. Right, I should probably go forward on my slides and not backwards. ThinkLegal, supported by Lawbox, practice management software for lawyers, by lawyers. Try Lawbox free for 14 days, lawbox.co.za. Also, Vermeulen attorneys for being very, very tolerant of me sitting on a Friday morning, not with my nose in files, and MV Incorporated, ADR and resolution attorneys, and the ladies who are involved in that are with me today, and you will meet them and get to know them. A special word of thanks to our speakers this morning who are joining me. First off, I am going to list Teresa Late, who is a mediator, a CFP, a coach, and all sorts of things. If I go into the bios of any of these three ladies today, we're going to spend a heck of a long time here. So I'll actually let them speak for themselves. I've put Teresa right on top because she's the one who whispered in my ear, listen, dude, we need to do a reframing mediation training, and she essentially conceived the whole idea of today's training. So thank you so much for that, Teresa. Looking forward to hearing from you later on. Then also Corin Malan. Corin is a mediator and an attorney and a director of MV Incorporated, Resolution and Mediation Attorneys. I look forward to hearing from Corin a little bit later, together in her session with Teresa. And then another Malan, no relation, Barbara Malan, from Barbara Malan Incorporated. She is an attorney and a mediator, and she has a phenomenally interesting section for us today on attorneys in mediation, or legal practitioners in mediation, which some of you may have seen as a paid session, but she has very kindly agreed to do a shortened version of it today as an open source type of talk for the benefit of colleagues at large. So thank you so much to these three wonderful ladies for joining me today in this session, and I cannot wait to hear what they have to say a bit later on. I will be doing a quick primer on the Gauteng Mediation Protocol, as well as Rule 41 Cap A amplified notices. You will see that a lot of what I will be discussing, those who were in my paid CPD sessions will see that I have shortened certain sections from that training, similar to what Barbara has done to put this into the public domain. If you are interested, and I'm putting this in simply just to save time because I've been receiving quite a few emails on this. If you are interested in getting hold of the recordings for those, I have, in the early wee hours of this morning, taken the time to actually pop those links onto our ThinkLegal store. So if you want to go and watch Demystifying Amplified Rule 41 Cap A notices, you can go to thinklegal.co.za. There is the link, as well as Unpacking Protocol Mediations. Both of these are CPD accredited sessions. It's 350 Rand to purchase, and you can then view the recording on demand and download the course packs from that. Save the date, folks, and unfortunately this is only for the Johannesburg crowd. Next year we will probably look at going a little bit further afield again, but for the Johannesburg crowd, we have once again decided to do a year-end mixer. I have very, very kindly volunteered Corin and Teresa, who are helping me put it together. And within a day, they found us a fabulous venue in Northcliffe, MV Cafe, no relation to MV Incorporated. We have a lot of seemingly related yet unrelated terms here today. 14th of November 2025, it is going to be an afternoon do. Tickets will go on sale on Monday once we've had all of our artwork and everything done. Speakers to be advised, although I have already secured my friend Mr. Louis Negrini, who a lot of you might know from previous industry events, who's an absolute treat to do the emceeing for the day for us. So please just save the date for now. It's going to be an afternoon session, and we look forward to saying goodbye to 2025 as a with a kind of function like this. We decided to do it an afternoon session again, so those who are that way inclined and would like to keep the party going afterwards may do so, if you catch my meaning. So, without any further ado, the introductions, program overview, plugs, etc., out of the way, let's get into it, folks. I'm going to go into the section called Understanding the Gauteng Mediation Protocol, a primer. The purpose of that is simply to acclimatize everybody in 15 minutes or so of what the protocol is, what it entails, and what the implications are for practitioners throughout Gauteng as well as further afield in South Africa. As we know, what happens in Gauteng really stays in Gauteng. It does either formally or informally peter out into the outlying jurisdictions. A good example of that is the financial disclosure affidavit, which has already made its way to the Regional Court Practice Directive, as well as informally to other jurisdictions. So this is probably something that is going to catch on in some way, shape, or form, folks. So it is good to know what it's all about. Thereafter, I will be handing over to Barbara, who is going to be talking about the human factor, role players, and personality dynamics in protocol mediations, where she's going to be talking about the roles of different people and their personality types, which is a fascinating, fascinating talk, and I look forward to seeing it again. And then finally, last but certainly not least, in terms of our formal presentations, Corin and Teresa will be presenting on strategic mediation, leveraging the process for client outcomes. Teresa told me a little bit about some of the things that you are going to hear from them today, and it is certainly quite fascinating, and I really, really look forward to going through that. Just a reminder, folks, please, AI note takers are not allowed in the room. Please do respect our IP and the IP of our esteemed speakers. If you do have an AI note taker, I respectfully ask that you would remove it from the meeting, which will save me having to scroll up and down, removing note takers the whole time as we go. You'll see I have a little bit of shifty eyes, not just because of my contact lenses, but because I'm looking for note takers the whole time while we go on. So, right. Thereafter, we will have an interactive panel discussion and Q&A, which I will facilitate from about 9:30 to 10 o'clock. We will be fielding some questions and answers. As this is a public domain webinar, you will note, unfortunately, that your cameras and your microphones are muted. However, you have access to the chat box and you have access to the Q&A. Whilst we are going through the presentation, and considering the very interesting nature of the subject matter we're going through, I do encourage all of you to pop your questions, comments in the comment box. The nice thing about having quite a few people presenting is while I present, I'm sure Barbara, Teresa, and Corin will be in the chat box chatting with you guys and vice versa. So please do pop that in. Furthermore, it's nice to not just see initials on a screen. If you are inclined and comfortable to do so, please let us know in the chat where you're from, what you do, and what you would like to gain out of today's session so we can have some conversation going as we go on with the presentation. And on that note, my schedule says at 8:15 sharp, we start with understanding the Gauteng Mediation Protocol, a primer. So let's go into that. Folks, the Gauteng Mediation Protocol was brought into being by the Judge President of the Gauteng Division of the High Court to deal with what was referred to in the directive as very severe backlogs, and to try and formalize the Rule 41 Cap A procedure, The directive was first circulated in March in draft form. In April, in final form, it came into effect, and then it was revised in June 2025. Please make sure that you have a copy of this directive in your arsenal, whether you are an attorney, mediator, mental health practitioner, or allied professional. I almost patted myself on the back for that pronunciation, then I tripped over my words right at the end. Whether you are a lawyer, mediator, mental health professional, or an allied professional dealing with litigation matters, it is worthwhile to have a copy of the protocol as well as the directive. Now, to understand the protocol and the directive, you must understand Rule 41 capital A. Rule 41 capital A came about just pretty much contemporaneously with the COVID years. It was round about that period, and I remember there were quite a lot of webinars at that stage on the subject matter, not because webinars were very popular in South Africa yet, but because that's all we had at our disposal during the lockdowns. But Rule 41 Cap A then came in and made it mandatory for parties to take a reasoned and a thought out view on whether or not they consented to the referral of the matter to mediation, or whether they opposed the referral of the matter to mediation and cogent reasons were required. Unfortunately, it was at that stage incorrectly touted as making mediation mandatory. It did not make mediation mandatory. It made considering a reasoned and rational consideration of mediation mandatory. Now, what is interesting is we sit with two distinct and two almost disparate processes that intersect under Rule 41 capital A, and this is quite clear, and you can see it is exacerbated by the protocol, which we'll look at very, very, very briefly. It is worthwhile studying the protocol and the dichotomies and all of the kind of nuances within it. But what is interesting is if you look at our Venn diagram, which I've got on the screen, you've got mediation, which I've put in blue, litigation in orange, and then Rule 41 Cap A, essentially where the two overlap. And it becomes quite a tricky scenario because you sit with two especially different processes. Now, why do I say that? Well, mediation is voluntary and consensual. As we all know, the mediator does not have the power to make decisions on behalf of the parties. It's confidential, it's without prejudice, it's interest-based, it's not rights-based. It's a facilitated process generally. It's creative, flexible, non-binary outcomes. It's party-driven. The parties are in control, and we see that in the protocol, and it avoids procedural rigidity. Litigation, on the other hand, is very much, in almost all of those respects, diametrically opposite to mediation. Where mediation is voluntary and consensual, litigation is compulsory. We know Constitution says that every person has the right to have a matter adjudicated or dealt with in the appropriate forum. And I've horrendously paraphrased it. And I know a lot of people say, well, mediation can also be an appropriate forum. Well, that's as may be, but litigation remains the compulsory if you cannot resolve your differences in a structured way. Litigation is public and on the record. For the family law guys especially, this is very, very relevant. Personal details floating around in some court file, in some court, or on some court database. Litigation is rights-focused, where mediation is interest-focused. It's rule-governed, judge-led, and what I mean by that is adjudicator-led. You have a judge sitting, hearing a matter, or a magistrate, not a mediator. Can you imagine having mediators as magistrates? And I know a few ex-magistrates who are mediators, so maybe that's not a good joke, but it is very much the presiding officer has the final say. Binding and enforceable subject to appeal, where mediation is flexible, non-binary outcomes, party-driven. Procedural compliance critical. I love this term, and I wish I could take full credit for it, but the heading compressed, that is an AI term. Procedural compliance critical, but no less important. You must comply with the rules of court. If you don't comply with the rules of court, you can get sanctioned, etc. And it's very evidentiary and fact intensive if you look at litigation as opposed to mediation. Then one could say never the twain shall meet, but the two do meet. In terms of Rule 41 capital A, you have procedural on the record elements to it, and you have off the record elements to it under Rule 41 capital A when you go to mediation. What I want you to note as a starting point for the discussions that will follow today is that Rule 41 capital A is essentially the embedding of an inherently informal process, which is mediation, within an inherently formalistic procedural system, which is litigation. That is expanded upon by the protocol. Now, for you to fully understand mediation under Rule 41 capital A, you need to look at the one photo on your screen. And I say one photo because this is the exact same image taken by a photographer from two angles. And your perspective on the process dictates how the process looks. And you can spend quite a lot of time looking at these two angles that they put together for these two photos, and it really is quite fascinating. The vantage points become quite interesting if you just change your view on it, and that is what Rule 41 Cap A requires of us, and that is where we start having to reframe mediation. If I can quote my friend Teresa, who conceived the idea for today's training session, we have to be able to see it from two perspectives, and that is what we are hoping to help you to achieve today. To fully grasp it, one must examine it through the dual lens of mediation as well as litigation. There's no shortage of training sessions doing the rounds now. I've mentioned the ones that I've done earlier. I know there are immense amounts of trainings by organizations, private individuals, on Rule 41 capital A, on the protocol, and on the interplay between lawyers, mediators, and the different processes. I do encourage all of you to take the time to attend some of those trainings, not necessarily my trainings. This is not a plug. This is an encouragement to go and upskill yourself, because we are turning into an ecosystem of professionals. We are no longer just siloed. The protocol in Gauteng especially is forcing all of us to play nice. And I must say, as an attorney mediator who kind of has insight into both industries, it is very interesting to see this awkward dance that's now happening between attorneys and mediators. And it's much like taking a bunch of cats that don't know each other, putting them in a room, and they're just kind of looking at each other, you know. But it is forcing us to become an ecosystem. And to survive in an ecosystem, you need to understand all facets of the ecosystem. That doesn't mean attorneys must now become mediators, but attorneys must be able to think like mediators. And mediators must not now become attorneys, but mediators will have to learn to deal with attorneys. Poor things. Anyway, let's move on. That's the two vantage points. Now, what is the foundation and the context of the Gauteng Mediation Protocol? The protocol finds its roots under the Uniform Rules of Court. The foundation of the protocol in Gauteng remains, will remain, and must always remain the uniform rule, and that is Rule 41, capital A. That is your starting point on any discussion on the protocol. If you are interested in reading the protocol, go read Rule 41, capital A first. Because if you do that and you start reading the protocol, you'll realize that the protocol is actually not much new. It fleshes out concepts that already exist. It's a how to the Rule 41 Cap A what. And that goes into the why. Right. So the protocol, as I said, gives effect to the mediation obligations embedded in Rule 41 Cap A. Now, what is very interesting is it takes it one step further. Rule 41 Cap A, the pure letter of the rule says you must indicate whether or not you are open to mediate with cogent reasons. Once again, paraphrased. Go read the rule. It doesn't say you must go mediate. The protocol takes it a step further. And the protocol essentially puts obligations on litigants to really engage with Rule 41 Cap A. And the stick that is imposed under the protocol is, if you don't, you can either be branded a delinquent party under the rule. You can open yourself up to Rule 30 capital A compliance proceedings, non-compliance with rules of court, Rule 30 capital A, or most damningly, you will not get a trial date. Okay, now that is quite a big sanction, and that is where a lot of people are having a lot of difficulty with it. So the foundations and context of the protocol, it was issued under Section 84B of the Superior Courts Act and Section 173 of the Constitution, which allows the High Court to regulate its own processes, as well as vests the head of court with certain powers to impose practice directions. It was brought about in the context of severe backlogs in the Gauteng division. It is very, very interesting to go read the directive by the Judge President when issuing the directive. It almost reads as an argument in favor of the directive and the protocol. A lot of time is spent saying, why are we doing this? It's almost as if the JP realized that people would not be very chuffed in certain professions. But it very much reads as a motivational letter for the protocol. It is worth reading. The intent under the directive is cited, and I paraphrase again, to restore timely access to justice. Essentially, the JP said, well, so many matters settle on the day of trial. In the interim, they take up an immense amount of court resources. These matters must be diverted to mediation early on to preserve court resources and make sure that the matters that get to trial are the matters that truly and genuinely require adjudication. Everything else must settle somewhere along the line. Right. Now, for those of you who are not au fait with the protocol yet, please do bear in mind it applies only to civil matters that are destined for trial. In other words, civil trial matters. Does not apply to urgent applications, does not apply to criminal trials, does not apply to motion court, does not apply to even Rule 43. Rule 43 is a funny one, and I mention it for a reason, because the underlying divorce action is subject to the protocol, and the Rule 43 could then be shoehorned into the mediation As it generally will, you know, in divorce mediations, divorce mediators will know if there's a Rule 43 order and you have to mediate, post the Rule 43 order, that order is a massive elephant in the room, um, blowing its trunk at you, and you have to deal with it before going into the merits of the divorce itself. Not resolve it necessarily, but deal with it, obviously. Okay. The protocol and the directive make one thing clear. This does not derogate from the judiciary's inherent power to encourage mediation more broadly. This is not the first directive dealing with mediation. Notably, family law practitioners will know the Family Court Directive in Johannesburg has requirements for mediation and statements about mediation for enrollment in certain matters. Judges may still direct parties to consider mediation where appropriate. Direct them to consider. Cannot force a party to mediate, right? Now, the protocol is somewhat coercive in that regard. To say otherwise, I think would be a little bit idealistic. You cannot get past having to truly show that you have considered mediation. It's very difficult to make out a case against mediation. It's not to say that there aren't cases which aren't capable of mediation. I think there are two extremes that we need to, as a mixed group of professionals, and I see lawyers, I see attorneys, advocates, I see some presiding officers, I see a lot of mediators, I see some mental health professionals here. What we need to stop is black and white thinking. It's the last thing that this world needs right now, and it's the last thing that our profession needs right now. What we need to realize is that there are two fallacies. The one fallacy is that no matters should mediate. The other fallacy is that all matters should mediate. The reality is in between. It is nuanced, it is fact-specific, and it is something that you need to apply your mind before you make a decision on it, and that is what the protocol requires. You will see in terms of amplified Rule 41 capital A notices, it expands on litigants' obligations, not just to say, I'll agree to mediation and this is why, or I refuse mediation and this is why. You have to set out various other factors pertaining to the merits of the matter, pertaining to admissions which you seek. It is not a boilerplate document, folks. For those of you on the ThinkLegal groups, stop asking for boilerplate 41 cap A's. It's not good for my blood pressure, and it's not good for your practice, because these are not boilerplate documents. You have to apply your mind in drafting them, or you're going to get you and your client into hot water. Now, what is the concept that we need to go back to? And I'm only going to clarify this one concept. In the CPD trainings, I did a whole bunch of them, but this is the only one. And this one is actually a definition that comes from the Uniform Rules of Court, and this is our starting point. What is mediation, folks? For purposes of mediation under the protocol, we follow the definition in the rules. That is the most authoritative indication that we have. And I've got 2 minutes left, so I need to finish up. Mediation is a voluntary process. First of all, the rules still say it's a voluntary process. You cannot force someone to mediate. The protocol says if you don't mediate and you don't have good reasons, you may have sanction. But according to the rules, I'm not talking protocol, rules, it is still a voluntary process. It's entered into by agreement between the parties. You need an agreement to mediate. Mediators, if one party asks you to mediate and the other party has not said anything, folks, with respect, you are not the mediator. You are a prospective mediator, okay? Both parties must agree, and they must agree in writing in terms of the protocol and the rule. Right. Oh, I love my soapbox this morning. It is a process in which an impartial and independent person, the mediator, assists the parties to either resolve the dispute between them or identifies issues on which agreement can be reached, or explore areas of compromise, or generate options to resolve the dispute, or clarify priorities by facilitating discussions. between the parties and assisting them in their negotiations to resolve the dispute. One would have thought I would have fixed this slide after the training session the other night, but I didn't. I'm sorry. Guys, mediation is not just trying to resolve the dispute as a whole. You can achieve other outcomes in mediation. The protocol requires that if you can't settle the merits, settle the process. If you can't settle all the issues, narrow the issues. Can we agree on 1, 2, 3? Absolutely. Go and box in the High Court on issues 5, 6, 7, and 8. But 1, 2, 3 doesn't require a judge. You don't need a policeman to tell you what you need to do in respect to this. Care and contact is sorted. Let's go fight about the accrual. At least we know the kids are sorted, you know, for example. Okay. Now, last slide before 1 or 2 plugs, and then I hand over to Barbara. We have 4 stages under the protocol. You need to be aware of this. The protocol doesn't spell it out, but it does envisage it. An expression of intent, it's your 41 cap A notices and replies. There are very substantial processes and requirements under the protocol for this. There's the referral and setup, that's mediator selection, appointment, joint minutes, agreements to mediate. You set the stage for mediation. Then there's mediation itself, and then there's post-mediation consequences. You need to be au fait with what happens in each of these processes. Right. ThinkLegal.co.za. Go to the website. Remember our year-end mixer, Northcliffe, 14 November 2025. It's going to start around lunchtime. Tickets on sale from Monday, together with our beautiful artwork as soon as that's ready. If you want to check out our CPD trainings,
Okay, it seems we've lost Mervyn for a second.
Can you guys hear me now?
Now we can hear you. Yes.
My screen just popped out. It's as if Barbara switched off my power because I'm 2 minutes into her session.
I had nothing to do with it. I don't have that technological ability.
The universe is saying pipe down for Mullen. You're not as cute as you think. Right, Think Legal. As always, guys, supported Lawbox for Mullen Attorneys MV Inc. End of my slideshow. On that note, I'm going to ask Barbara to start sharing her screen again.
And Barbara's going to cross her fingers.
Right, can Barbara find her screen? Let's get her going. So, as I said earlier, folks, if I go into our esteemed speakers' full bios, I will keep you here the whole day. Suffice to say, Barbara Malan is the director of B. Malan Incorporated Attorneys. She is an attorney. She is a mediator. She even does tax consulting. She has a CV that is very, very impressive indeed, and she has devised this section on role players and personality dynamics in mediations, which I think is fascinating and is really worthwhile for all of us to know. So please use all of your reaction buttons and help me in giving a very warm welcome to our next speaker, Barbara Malan. Over to you, Barbara.
Thank you very much for that very sparkling introduction. Setting me up there. Thank you very much for having me. So people who have watched or have had me present before know that I always start with a very short personal disclaimer. For what I have to share is generally quite a lot based on personal experience, because I'm an attorney and, as Mervyn said, and a mediator. It's funny that I always say attorney first, but that's the current position. I was actually a mediator before I became an attorney. So sometimes I deal with mediators as an attorney when I'm referring clients to mediation and now drafting Rule 41As, etc. Or I deal with attorneys who would be as colleagues usually, who are referring matters to me as the mediator. So as you can imagine, dealing with attorneys, mediators from the 2 different perspectives is quite interesting and can be challenging. So bear with me. It's not my intention to offend anyone. So when I first completed my mediation training, I was not an attorney. I just completed my honours in clinical psych, and I was applying for my master's while on my way to enter the helping profession. The only experience I had with attorneys was in the co-mediation space, because at that stage I did my training at FAMSA and co-mediation was the flavor of the day. They'd take off the attorney hat, they'd step into the mediator role, but in the attorney the legal profession or the legal profession mediator. And then I would be the mediator as the helping profession mediator. These attorneys are trained like me, so they understood mediation and they understood the process and the value, especially in family law matters at the time. Mediation was not then legislated, but had since the early 90s become a fast favorite to resolving disputes as an alternative to litigation. I then dealt with attorneys in the medico-legal space. I was working for an industrial psychologist and who did mainly RAF and personal injury matters, and these attorneys would refer matters to us. These attorneys that referred were generally the suit-wearing, briefcase-toting, winner-takes-all professionals that we've all come to know in the legal space. They're professional, they're austere, they strive to promote their clients' interests at all costs. And today, the attorneys referring matters to mediation are often the very same people I've just described. They've come to believe they've got no role to play in the mediation process. Some even believe they might hinder the process due to their adversarial orientation, and this is often the case. These attorneys, I found, often play lip service to the mediation process. Now, with Rule 41A, they see it as a tick-the-box exercise, an inconvenience that they must let play out for 30 days until they can then get back to their litigation and earn some fees in the process. Unfortunately, I think this is evident in some of the Rule 41A notices we're seeing in Gauteng at the moment. The bottom line is that these attorneys, as a general rule, see no value in mediation and that it's only serving to take away clients and fees from them, which equals the death of their practice. On the other hand, we have attorneys who've had exposure to mediation, either that it's now in their training as the younger attorneys coming up, or they've had it, as I say, in the previous mediation space. They either have more or total faith in the process and they see the value for their clients. The mediation process, or the mediation protocol, has put these attorneys and clients in one boat, whether they want to be there or not, whether they've got faith in the process or not. But mediation is here to stay, and the protocol must be adhered to, as Mervyn mentioned, with quite harsh consequences if it's not. If the mediator understands the type of attorney they're dealing with and the attorney's expectation of the mediation process, and if the attorney in turn can understand the mediator and their process, they can assist the mediator in managing their parties' clients' expectations and assisting them throughout the mediation process. And by them, I mean the client and the mediator. Even though the mediation is client-driven, the mediator is still steering the ship through the choppy waters. If the attorney doesn't feel superfluous or a third wheel, they're more likely to invest in the process. And if the attorney is invested in the process, their client is certainly more likely to also invest in the process, which then makes it much easier for the mediator. The rule of thumb is the client is always going to follow their attorney. They're always going to be led by their attorney. Paul Hoffman, in an article of 3 April 2025, which was just around the time that the mediation protocol was coming out, speaks to the fear of attorneys, the practice-ending fear. And he states, mediation is to some lawyers what the internal combustion engine was to most farriers. And he clarifies this by saying, farriers are the folk who shoe horses. The demand for their services dwindled sharply when the horses they had back in the 19th century were replaced over time by the use of the internal combustion engine in cars, trucks, and other forms of transport. Some major league litigators in Gauteng and elsewhere are behaving as though their profession is faced with extinction event, more severe than that suffered by the farriers of old when horses became as redundant as some lawyers now fear they will be their lot should compulsory mediation be allowed in law. This, however, does not need to be the case. Again, if you as the mediator understand the fear base from which attorneys are approaching mediation, and none of them are going to admit that it's a fear base, you can address it early on. Understanding breeds collaboration between representative attorneys and the mediator, and which then directly affects how the parties will mediate, in good faith or in bad faith. Sorry, my slides froze. There we go. In practice, I've been faced with two attorneys, which I refer to the attorney on the sidelines and the attorney in the room. The attorney on the sidelines, this is the attorney who refers their client to mediation but does not participate in the actual sessions. They do not want or expect to be in attendance in the mediation. They are, however, available to their client and even the mediator if necessary to provide support throughout the process. And this is either during the mediation, they're sitting in an adjoining room, or they're just available and accessible if necessary. Then you've got the attorney in the room. This is the attorney who wants to be part of that process and by active participation in and attendance at the sessions. They've prepared their clients and now they want to follow them into the room. If they cannot follow them into the room, they want to be sitting right next door, ready to jump in at any time they might be needed by their client during the session. Importantly, just to note, just because the attorney is on the sidelines, it does not mean they are sidelined. And both of these have, I say, cons and pros, because the cons do sometimes tend to outweigh the pros, such as impacting the power dynamic in the room, too many cooks in the kitchen, diminishing trust or faith in the mediator if they're sitting there and the party keeps deferring to the attorney. And there are pros. The attorney has intricate knowledge of the matter. It's a complex matter. It's sometimes RAF, or there's extensive expert reports that need to be explained. Then they do serve a purpose. And in my longer presentations, when I've got more time, I do I unpack some of these. But the advice from this to mediators is that if you are going to allow the attorney in the room, it is important to remember that the attorney, to all intents and purposes, is a guest in mediation. You are the mediator. This is your forum. You've done the training. And you are assisting the parties to reach their desired outcomes, not the attorney. You are not there at the attorney's convenience. So do not be afraid to set boundaries early on. Again, the parties drive the process, but you are assisting in steering the ship. And if there are too many captains, the ship's going to capsize. I do get quite a few calls from people in the helping profession that seem to be a bit intimidated by some attorneys, and that doesn't need to be the case. We're all in this together. Right. Part of my employment with my industrial psychologist involved career assessments. So we often discuss the type of people or personalities that drew people to certain careers. This can be especially helpful for a mediator trying to understand the attorney with whom they are dealing. So I'm going to digress slightly from the mediation process, and if you grant me some leeway, look into some useful tools to build understanding between mediators and attorneys. So whether you put stock in personality questionnaires, I find them quite interesting. There's the popular Myers-Briggs type indicator, or MBTI. That categorizes individuals into 16 personality types. The Kiersey Temperament Sorter is a self-report personality assessment created by psychologist David Kiersey and was introduced to the public in his 1978 book, Please Understand Me. And I have the links at the bottom. If anybody wants to provide them, they can email me. Kiersey's questionnaire divides people into 4 temperaments labeled artisan, guardian, idealist, and irrational. And then each of these 4 temperaments is further sorted into character types, which lead to a total of 16 personality types in total. So it ties up quite nicely with the MBTI. Kiersey, however, used the form temperament instead of personality, as he believed that temperament is made up of personality traits that can be observed, and which include the way one typically communicates, the kind of action one takes to accomplish their goals, and their talents, values, and preferences. And as you can see, all of these items or these traits fall into the mediation space. People are communicating, they're taking action, they're trying to accomplish goals, and it's all based on preferences, talents, value systems, all comes into mediation. So according to Kiersey, and I am going to read these so I don't miss anything out, artisans tend to excel in the arts or anything that requires creativity. They are concrete and utilitarian, which means they're talented at working with solid objects and confronting real-world situations. The artisan personality types are composers, crafters, performers, and promoters. Guardians are dependable, hardworking individuals who keep the wheels of society turning. They are concrete and cooperative, which means they follow the rules and respect authority. They are dedicated to maintaining law and order and believe in customs and traditions. Guardian personality types are inspectors, protectors, providers, and supervisors. Idealists tend to focus on personal growth, self-improvement, and people reaching their potential. They are abstract and cooperative, and as a result, they strongly believe in working together harmoniously to pursue what could be rather than what is. They are loyal, honest, and kind, and tend to pursue careers that enable them to help people. Idealist personality types are champions, counselors, healers, and teachers. Rationals are the rarest of the 4 temperaments. Rationals are problem solvers who enjoy figuring out systems, whether those systems are organic, social, mechanical, or something else, and determine how to improve them. They are abstract and utilitarian, which means they are pragmatic in their approach and interested in abstract concepts that underlie whatever systems have caught their interest. Rationals value intelligence, independent thinking, and logic. They often become completely absorbed by whatever problem they are trying to solve, making them seem aloof or withdrawn. Rational personality types are architects, field marshals, inventors, and masterminds. Both the MBTI and the KTS2 tests are widely administered in the legal community, and they generally confirm what we already know. Lawyers, be they attorneys or advocates, personalities are different from those of other professions and from those in the general public. We're special people. Attorneys generally fall into the guardian temperament, a personality type that values order, stability, group membership, and rules, whereas mediators are more likely to fall into the idealist temperament, mediating, motivating, conciliating, developing, educating, and guiding. However, as we're going to see below when we look at the LLH lawyer types, attorneys and mediators may have more in common than they realize, because attorneys can fall into the idealist temperament, in which the mediators are placed. So LLH, who's part of the ADICO group, which is a talent advisory and solution company, has specifically applied the above to lawyers. And they found that when standardized personality tests are administered to lawyers, the results tend to be quite different from those that arise in the general public. Again, special animals. They advise that understanding the different personality types of lawyers, and again, they mean advocates and attorneys, is key to navigating legal careers. From the advocate to the litigator, each type shapes how lawyers approach cases and interact with clients. LLH have applied some of the MMPI's and the QSE's findings to formulate their own categories of lawyer personality types. They do, however, lead with the following caveat. The 5 types listed below are simply approximations designed to provide a framework for considering personality information on complex individuals. Needless to say, the list is not intended to be comprehensive or exclusive. It's only a snapshot of 5 personality types commonly found in the legal community. And I'm going to go into the 5 lawyer types developed by LLH, and again, I'm going to read verbatim. So first we have the rainmaker. Not surprisingly, a successful legal salesperson is a people person, an extrovert who thrives on the give and take of social interaction. Rainmakers are empathetic, interpersonally adept, and skilled in the persuasive arts. They build and maintain trust, and their confident, assertive nature makes it easy for them to ask for the order. Rainmakers are also known for goal orientation and resilient egos. So if their sales pitch is turned down, they simply pick themselves up and try again. The advocate. This personality type might be found in a public interest law firm, a non-profit, a government regulatory body, or any place where there's a commitment to serving a greater good. Core values for these lawyers include unity, morality, ethics, authenticity, and social justice. Although social scientists have observed a shift towards external rewards, such as money, power, and prestige that occur in most law school students, members of the advocate group retain their loyalty to internal values. Advocates are well aligned with what Dr. Kersey calls the idealist temperament, typified by the search for meaning and significance in one's work. And there's the crossover between your attorney and your mediator. The litigator. Through a self-selection process that begins long before law school, individuals pursuing legal careers become increasingly more competitive and results-oriented than members of the general public. Those lawyers who pursue the subspeciality of litigation, however, take these competitive traits to a new level. What's more, these amped-up attorneys are overwhelmingly characterized by what Kersey calls the rational temperament, valuing logic, expertise, rationality, concept mastery, and precision in the use of language. The corporate. Practicing law in a corporation or other large organization requires capabilities that go beyond technical expertise alone. In these arenas, the so-called soft skills become core competencies for success. Trustworthiness, listening skills, and emotional awareness, diplomacy, and other human relations capabilities are the coin of the realm for successful corporate lawyers. Again, excellent judgment and management skills are taken as a given for these positions. In Kiersey's terms, corporate lawyers might fall into the guardian temperament, a personality type that values order, stability, group membership, and rules. Finally, we have the inspector. Last, let's consider as a group the many hardworking, technically competent lawyers who reliably keep our legal processes functioning every day. In recognition of Kiersey's temperament description, we call this lawyer the inspector. For these personalities, Kiersey chose the adjective super dependable, and thankfully the legal profession includes many conscientious members who exhibit these traits. Inspectors value their inclusion as respected members of a community. Even so, they may not aspire to positional leadership or the visibility that accompanies these roles. Avoiding the limelight, the contributions of these reliable professionals easily can be overlooked. If you know one, and you most likely do, make a point of recognizing their steady contributions. Also worth noting, in MBTI terminology, this inspector personality type reportedly constitutes the single greatest concentration of lawyers in any one of MBTI's 16 personality types. So I find the above is a helpful tool in assessing the type of attorney you are dealing with, and which in turn will promote a cooperative relationship between the mediator and the attorney. Gaining insight as the mediator into the parties and their attorneys is an invaluable tool for mediators. And this, again, understanding and communication is key and will guide you as the mediator as to how the mediation process might progress to the optimum benefit of the parties involved. And I see I've just got a little bit of time left, and you might be asking, how do you assess the attorney before the mediation? Use it, don't use it, take it with you. I hold a pre-mediation meeting with the attorneys alone. It's a half hour to an hour. It's on Teams, because trying to get two attorneys in the same room at the same time is often like herding cats. But the pre-mediation, you have the attorneys in the room without their clients. They can then speak freely. And if you have an attorney that doesn't understand mediation or has questions, they can ask you those questions without perceiving or losing face in front of their client, because they're supposed to know all and be all for their client. So I hold a pre-mediation session. I take them through who I am. I take them through my process. I generally advise them I'm not going to really let them into the room unless their clients really insist on it. But there in the pre-mediation session, you are going to get to know the attorney, and you'll see the type of attorney and the ego and the perceptions that you are dealing with. And that's me. I'm a little bit early.
Fantastic. Thank you so much, Barbara. That was fascinating. Guys, please, can I ask, can everybody just give Barbara a very, very warm round of applause? That was a phenomenal and very, very interesting. I see some of the guys say that, will the slides be available, because keeping up with your classes may be challenging, Barbara. So I don't know whether that is a compliment or not, but certainly fascinating stuff. I think one of the big opportunities that we have is really putting the guardians and the idealists in a room together, and that's really where I think a lot of the magic can happen. I think it was Walt Disney that spoke about the dreamer, the critic, and one other one, and never the three should meet, or something to that effect. And now obviously we all have to meet. So thank you very much, Barbara, for your presentation, the human factor, role players, and personality dynamics in protocol mediations. I am very, very pleased and honored to present our next two speakers, Karen Malan and Teresa Late. Karen is a director of MV Incorporated. She is a mediator and attorney, and Teresa is a consultant at MV Incorporated, and Teresa is a mediator, a coach, a CFP, and also the one who had the brainchild to put on today's presentation. I'm going to segue from what Barbara said in terms of the pre-mediation meeting, folks. You'll see that the protocol allows us to be flexible in its interpretation. You'll see right in the first 2 paragraphs of the protocol, it says that the protocol is intended to be a flexible, uniform framework for mediation to take place. And one of the things where I think there must be some consideration on whether flexibility is necessary is on the idea of the pre-mediation meeting. The pre-mediation, as Barbara pointed out earlier, can be a very powerful tool to build rapport with the attorneys, and if used properly, can really set the stage beautifully for the mediation. I know, very cheekily, that's one of the things that Teresa and Karen will be talking about. So I get to do this segue and pique all of your interest in terms of what will be said. Without any further ado, it gives me great pleasure to welcome Corin Milan and Teresa Late. They will be talking about strategic mediation, leveraging the process for client outcomes. As we did for Barbara, let's give them a very, very warm round of applause. Go to your react buttons and let's give them a hand to welcome them and make them feel ready. Oh, fantastic. You guys even got a heart. There we go. Good. Over to you, Teresa and Corin.
Okay, thank you, Mervyn. I'm going to start, and then me and Corin are, we jokingly refer to married in community of property work wives. So I think where the concept arose for me, well, firstly, to introduce myself as well. Like Mervyn says, if you have to read my CV, you will realize that you don't need to meet me. You will understand that the ADHD is strong. The force is relevant here. I am one of those people that couldn't decide what I wanted to be when I grow up. And I'm very thankful to have found mediation a couple of years ago, because I think this is where my home is. It is such a combination of psychology and law and people serving and giving back to communities and to families, because we mostly work in family law, that it provides an opportunity for me as a mediator to really bring benefit to any family in terms of a dispute. So where this comes from for me was firstly because I felt that most attorneys especially, and for those mediators online, you're very welcome to use some of my motivations that I'm going to give today, but I'm going to mostly speak to the attorneys in terms of the benefits and the gains, and me and Karen are going to discuss that. We are also going to provide the attorneys with a little bit of a playbook. We call it a playbook. We're going to give you some tips on how exactly, in a very practical way, you can actually be of service to your clients within the mediation process. And we're also going to talk about some objections that we've had from attorneys, and we're going to address those, and we're going to answer those questions for you. So without further ado, let's start with reframing dispute resolution as a specific concept. So the first thing that we need to understand about where we're going with this is that the protocol and the mediation is here to stay. The exact way this protocol is structured might not be completely what it's going to grow into when it's nice and big, when it is an adult, but it is never going to go away, because the research and the proof that we have seen of the benefits of mediation internationally is actually irrefutable. So what I want to do today is I want everybody to understand that every single one of these concepts and these tools for dispute resolution is part of a process. Whether it's dialogue, whether it's mediation, whether it's arbitration or litigation, the one is not more important than the other. The one is not above the other. It should be seen in context, and it should also very much so be seen as tools at the disposal of legal and psychology professionals to actually help people in dispute. So there's a couple of things. The first is that it is part of this dispute resolution framework. We just had the Social Justice Conference in Cape Town, and I see Joe's talking about a conference for KZN Society of Mediators. And our topic this year was integrated ADR in systems and professions and disciplines and how we can make that happen. One of the things that's very important for me when you start rethinking as an attorney about how you should see mediation is that it is not a soft option anymore. It has very real consequences if it's not applied properly. And that's where I want to say that the protocol is forcing us not to mediate. The protocol is forcing us to use the appropriate mechanisms for a specific dispute that our clients are facing. Attorneys who understand this process have a distinct advantage because they know the process and they know the benefits and they know how to leverage this. And this is a short training today. We're only going to give you a couple of tips. Please watch the space. We're also working on more extensive trainings in how we can actually help attorneys to reframe the whole process and how to make use of mediation as the proper tool in dispute resolution more than anything else. I also want to reiterate that as someone that's been mediating in the family sphere for quite a bit now, quite a long time now, me and Karen are partners and we've been doing this for a while now. The parties that we see that have attorneys behind them that know the process, understand the process, and is invested in helping their clients, coaching them, helping them, assisting them. Those are the clients that see the most benefit and the best results coming out of the mediation because they have been placed in a situation by their legal counsel to make educated decisions and not only emotional ones. So we're going to talk a little bit about the advantages and the benefits of the mediation, and the first aspect is going to be procedural gains, and Karen is going to talk to us about that. Thank you so much, Karen.
Good morning, everybody. Thank you very much for Mervyn and Teresa for introducing me. So I'm not going to introduce myself again, but I'm very happy to be here and excited to be part of this discussion. Let's look at the strategic wins for family law clients. Family mediation isn't just a tool for clients, it's a powerful procedural ally for attorneys as well. And when used effectively, mediation can streamline case management, reduce litigation risk, and enhance client satisfaction. So the first procedural gain is issue narrowing for focused strategy. The advantage for the attorney here is it reduces the scope of disputes, allowing for targeted legal representation. Attorneys can guide clients to agree upfront on uncontested matters such as parenting logistics, asset division or interim maintenance. This enables attorneys to focus on high stakes or complex issues without being bogged down by peripheral disputes. The second one is time leverage without procedural prejudice. The advantage here is that it creates strategic breathing room for recalibration and client management. Mediation suspends litigation timelines without procedural prejudice. It gives attorneys space to reassess strategy and manage client expectations without risking procedural default. It also gives clients breathing space, and sometimes it's very important because it calms them down and it helps them to think in a way that what they need and what they want, that they actually look at the bigger picture. This pause is especially valuable when clients are emotional, reactive. The third one is joint expert instruction for procedural efficiency. The attorney's advantage to this is that it reduces evidentiary conflict and enhances credibility. Attorneys can benefit from jointly instructing professionals such as child psychologists, parenting coordinators, actuaries, or child participation specialists. This avoids duplicative reports and conflicting expert testimony. Joint instructions are also helps to reduce costs and improve the likelihood of mutual acceptance of findings. And the fourth one I identified, which is also important, is the strategic realignment of clients' expectations. The advantage for the attorney here is that they have the mediator support in managing unrealistic demands from their clients. Attorneys often struggle to convince clients to temper emotionally driven or legally unattainable expectations. Mediation provides a neutral space where clients can hear reality checks from a third party. This can lead to more reasonable settlement propositions and reduce the risk of prolonged litigation. Over to Teresa.
Teresa must remember where the mute button is. Okay. Okay, so the next topic we're going to talk about, which is very exciting for me, because this is the things that have implications on your relationship with your client. So the first one that I really feel is an important one that I hear attorneys and friends of mine complain about all the time is mediation reduces the conflict spiral and unnecessary escalation. We all know, especially, look, I'm going to use a lot of examples from family because that's mainly where we specialize. But you get clients that are in this divorce, they have children together, and due to the interactions they still have with each other on a daily basis, they can really actually like work each other up. And it is actually very, very detrimental to your relationship as an attorney with that client, because they sometimes sabotage your process because their emotions are actually going completely off the rails. One of the examples that I always think about when I think about this is a client that we especially struggled to actually get to the table because she was convinced that he's never going to give me anything. It's not going to be successful. All she was doing was crying. We did the pre-mediation and this poor woman was just crying all the time. At the end of the day, she got such an amicable settlement at the end of this mediation that she didn't expect, because his attitude was, this is the mother of my son. I'm going to have to face him one day. This is something that we helped that couple with facilitation to get to in their own time, which benefited the attorneys because this attorney looked really good because they actually could help this client negotiate the settlement through the mediation. It preserves the relationship if applicable. Now, this is where the complication lies with some of the mediations, because it's not like you're going to do a mediation, there's going to be a settlement like when there's a contractual issue and these people are just going to be removed from each other's life. When they have children together, when they are going to have to keep on being business partners or colleagues or work colleagues or whatever the situation may be, there is a relationship there to preserve. If you as an attorney can help them to at least address that relationship, you are already gaining a lot of favor with your client. The next point that I really want to reiterate is that all mediators, it's part of our training. It's one of the first things you learn with most trainings is that mediation operates in the shadow of the law. And when you say that to attorneys, they look at you like you completely lost the plot. So I want to address that today. Shadow of the law means, yes, we can't do anything that's illegal. Karen's going to refer to that again. But we can also negotiate without following the letter of the law blatantly, because there is a lot of confidentiality without prejudice, so we can apologize to each other without prejudicing the attorney's strategic process. We can come to agreements that we never would have done an example for me, once again, is a couple of months ago that were married out of community of property without accrual, and they still managed to get to some sort of financial settlement simply because they have realized that there is a relationship to control on that side, because they have children together, they have grandchildren together. So that's some of the advantages that you can bring to the table as an attorney. Reputational capital. So yeah, I want to ask, if you're an attorney, do you want to be known as someone that's a problem solver? Do you want to be known as someone that's child-centered? Do you want to be known as someone that's a settlement attorney? Do you want to be known as someone that have shorter turnaround times than any of your colleagues? So there's also benefits to your practice in terms of reputational capital in that regard. Because if you can see more clients and manage to finalize more cases than just putting your proverbial eggs in all one basket, because you only have the time to deal with 3 very heavy litigated divorces, there would be a financial gain for you as well. So what me and Karen have also done in that regard is then, on a practical level, how do you help your client? What do you do in different phases and different aspects? And Karen is going to talk to us a little bit more about some of the tips we have for attorneys. Please, mediators, take notes, because this is how you can talk to the attorneys in your tribe.
Thank you. So how can attorneys assist their clients? I've divided it into 3 phases. It's the pre-mediation phase, or the pre-mediation strategy. What is the strategy during mediation? And what should the attorneys be doing after mediation, meaning post-mediation strategy? So if we look at pre-mediation strategy, we need to understand attorneys need to understand the mediation process. Before they can guide their clients, they need to familiarize themselves with the core principles of mediation. Mediators obviously get their training, but attorneys aren't always aware what the core principles are of mediation. And if attorneys take the time to actually familiarize themselves with it, they can assist their clients in a better way. So what are these core principles? The first one is confidentiality. Teresa has touched a little bit on that, and Barbara as well. It basically means, if I can break it down, is what is said during mediation stays in mediation. This encourages parties to be open and honest, because the whole conversation is protected. As attorneys, you would know the legal term without prejudice. The voluntary nature of the mediation process is the second core principle. And this is very important, because nobody can force anybody to mediate. The parties must engage willingly. Coercion undermines the process and can invalidate the outcomes. So the people need to feel, first of all, safe, and they need to know that they can at any time say that they do not want to continue with the mediation process. We can come up with creative solutions. That's the third core principle. And Teresa has mentioned operating within the shadow of the law. I always say that mediation is empowering, because the reason is that the parties themselves are in a unique position to make decisions for themselves. Because if they are in court and the attorneys' arguments are heard, that decision is completely out of their hands. The decision is either made by the magistrate or the judge, but in mediation, they have this unique opportunity to make decisions for themselves, because they themselves know their situation the best, and they know what works for them and what doesn't work for them. So in that, it is very empowering, and I've seen it on a daily basis. Operating within the shadow of the law is exactly what Teresa said. We can be flexible with our decisions as long as we work within the framework of the law. We can't make decisions in mediation that are illegal. We need to make sure that we know what the law says so that we can make decisions within the framework. The second one is drafted value agenda. This is your strategic blueprint. It is not just about what your client wants, but also what they value. Identify as the attorney, identify non-negotiables and aspirational goals of your client. Include fallback positions in case of when settlement fails. Consider emotional and the relational priorities, especially where children are involved. The third leg here is prepare your client's expectations. Clients often enter mediation with a courtroom mindset. Reframe their thinking as their attorney. Mediation is not a trial. It is a conversation, and it is a powerful conversation. Mediation is a tool to simplify court. Even if no final agreement is reached, mediation can narrow issues, reduce hostility, and protect children from conflict. We need to also understand that mediators, they are not judges. They do not make decisions. They only facilitate a conversation so that the parties themselves can reach an agreement. The last one I identified in the pre-mediation strategy list is show support for the process. It's important that the attorneys show the clients that they support the mediation process because your attitude and tone is important. If you as the attorney are skeptical, your client will be too. Express confidence in mediation as a valuable tool. Encourage active participation and honest dialogue, and help your client to feel safe and empowered. And in that, engagement will be boosted and the quality of the outcome will be so much better. The second phase, is the strategy during mediation. So what can attorneys do during mediation? They can narrow issues. They start by identifying uncontested elements. For example, parenting schedules in a parenting plan. Maybe the parents have already sorted that out and it's not a big problem, or holiday routines. Basic maintenance agreements, maybe regarding the children. So why does that matter? It matters because it reduces the scope of the conflict if attorneys are able to identify uncontested elements. It creates psychological process. It builds momentum. Everyone just keeps building that momentum, and it's so positive and powerful within a mediation process. The second one, emotional intelligence. Be the calm in the storm. I cannot emphasize this enough because attorneys need to be there for their clients, but they must remain calm and support the mediation process, because mediation is emotionally charged. Your role is to anchor your client, not escalate tension. Allow space for acknowledgement, moments where parties express grief or regret. Don't weaponize every statement that is made. Clients need the room to process emotions, not fear that every word or that every offer that is put on the table will be used against them. Be present for your and patient with your client during the process. The third one is confidentiality sandbox. Exchange creative exploration. Remind your clients that mediation is a safe space. It is a space where you can be open and honest so that solutions can be found. It is a safe space that you can come up with offers because everything you say stays within the room and stays within the mediation. Proposals are without prejudice and they cannot be used in court. Encourage bold ideas because with bold ideas comes solutions and the creativeness of bold ideas are very powerful in mediation. Disclosure is key. The more open parties are, the more likely parties are to settle. The last one is solution focused. Shift from blame to building. Help your client evaluate offers to clarify, offers with clarity and realism. Frame proposals as opportunities. Offer alternatives rather than objections. And then be the architect of this resolution, not a critic. And then the last one is how can you assist your client after the mediation process has been finalized? One is bank partials in the joint minutes. Basically, it means that even if there isn't a full settlement or reached, every solution or every issue that has been resolved counts. Lock them down in agreements. This will reduce the burden to trial and narrow the issues and will save, obviously, time and costs. The second one is leverage the mediator's report. The mediator's report is more than just a summary. It's a strategic asset to an attorney. Use it to highlight your client's reasonableness, openness to settlement, and constructive behavior. Courts may even consider this when assessing costs in favor of your client. A well-documented mediation report can counter accusations of obstruction and bad faith. Do not sabotage. Honor agreements in principle. If the parties reach a conceptual agreement, your job as attorney is to facilitate, not frustrate. Avoid reopening settled issues or introducing unnecessary complexities. Bring positive contributions to drafting the process. Clarify and redefine, but don't derail. Respect the spirit of the agreement and help translate it into enforceable terms. The last one is don't stall. As soon as there's agreement, please act swiftly, draft the agreement and to finalize the process. Do not drag your feet as an attorney. Avoid unnecessary delays because this can reignite conflict and cause one party to withdraw. Provide clear timelines and keep your clients informed of the next steps. Over to Teresa.
Thanks, Karen. Okay, so we are planning to extend that at one stage, but there's a couple of objections that I've heard from attorneys that I personally felt very strongly about addressing before we move on. And I'll quickly respond to some of them specifically. Where we're at. There we go. The first one is clients won't agree to mediate. I often get this one. You know, if you've got a mediator that actually can speak to someone that can do a pre-mediation, whatever, get your client to just agree to the pre-mediation. A mediator is equipped with the skills, a properly trained and accredited mediator is equipped with the skills to explain the benefits of the mediation to them themselves. I often say to parties, if the one comes to me and approaches us for mediation and they have this opinion that, you know, but you'll never get her to mediate or you'll never get him to mediate, I often joke and say, remember, they're angry with you, not me. So don't underestimate a mediator. The second one is we can't settle everything. I think today we've addressed that. there is ways that we don't talk about an unsuccessful mediation ever. We talk about an outcome for a mediation is an outcome for a mediation. So at the end of the day, we must see every conflict as also in its portions and assist the client to tell people that we can break it down for them, and we can even agree to portions or procedures, or we can maybe agree to using some professionals, for instance, to save money, as Karen was referring to, child participation, interview people, even socio-emotional reporting or forensic investigations when there's children. When it's financial stuff, they can agree to use a specific actuary or a specific chartered accountant, or all sorts of financial advisors can be used. The options are many. So one of these is also, this is just a delay. I hear attorneys say this often. Mediation provides a delay in the process, but on the long term, it actually shortens the process, even if it is only because we can agree to some procedural rules to how we're going to move forward with a specific trial, or how we're going to move forward with a specific professional person, but there is long-term benefits in that. So I actually do not see mediation as a delay. One attorney said to me, but this is just another roundtable. For any attorney out there, there's quite a lot of, I've looked through the people that are online, there's quite a few reputable mediators online today. Please, go have a discussion with one of them about maybe where they can explain to you some, without compromising clients, but of some of the settlements that they've actually achieved, because it's not a round table. A mediator is a very specific person that is trained in asking the right questions, staying objective, helping people create empathy for each other through facilitation. It is definitely not a round table. Appointing a mediator is too expensive. It's unnecessary cost. I had someone last week an attorney at the conference, which I must commend them because they did attend an ADR conference, ask me this exact same question again. So I want to ask, what is the cost in litigation? Because remember, we're talking high court mediations here. So in high court, it is possible, but it's highly unlikely that someone's going to be representing themselves. So if someone has legal counsel and an attorney and maybe a senior counsel or a junior or a whole battery of learned people for 3 years versus for 5 years in a litigation process, because a mediator could maybe just, help narrow some of the issues, what would the cost saving be then? Would they then be able to afford the mediator's fees? Just a question. What if I don't like the mediator's outcome? This one just made me shake my head, because I saw this actually as a comment on X straight after the mediation protocol was actually promulgated on the 22nd of April this year. So this guy was asking, what if I do not like the mediator's outcome? It is vitally important that you understand what mediation is before you actually comment on something like this, because it's never the mediator's outcome. The mediator is a neutral third party that is there to facilitate parties, to assist them to come to their own decisions. It's never the mediator's decision. So this is just some of the questions that I've had from attorneys in the past. But I want to leave you with just one parting conclusion to make you think a little bit differently about mediation. Firstly, family mediation is not about kumbaya. It's not counseling. It's a strategic litigation management under the Gauteng Protocol. It is part of the process. It is a tool that you as an attorney can use to assist your client. So I want to leave you with one parting mind shift. Even if my case as an attorney doesn't settle, mediation will buy my client clarity, credibility, and compassion. 3 currencies that our courtrooms rarely provide. Thank you very much. We will address the panel. Thank you, Mervyn, for the opportunity. I think I did this under, there we switched to 8:35. So I think our timing was good. Thank you, Karen, for your contribution as well.
That was fantastic, ladies. Well done. Folks, please give them a warm round. I see the emojis coming in. I must also just add, as an aside, at my own expense, I was getting quite paranoid. I see we're on slide 17 of 36, and I'm like, oh my goodness, are these ladies going to finish? But well done, right on the money with closing up. So, folks, I'm going to go into 25 minutes of panel discussion and Q&A. Barbara, if I can please ask you to also just switch your camera on. There we go. I'm going to pop myself into the spotlight as well. And I'm going to paraphrase or put a few questions to you. We got some really lacquer comments in the question box or in the meeting chat, and I'd like to get through all of them. The first one, I'm actually going to ask all 3 of you to chime in on this, and I think it's a massive question for mediators as a whole. And the question is getting attorneys and clients to realize or understand that a mediator does have solid training and can be trusted / respected as a mediator, even if not a legal practitioner, is something that I would like some insights on how to install that trust. And that is, I mean, let's get real. That is one of our big objections that we get from lawyers, is criticizing the mediators. So I'm going to ask Barbara to perhaps jump in first, and then Karen, and then Teresa, if you guys don't mind. Barbara, sorry, putting you in the hot seat first.
No problem. Luckily, this is one of those I have a bit of a passion about. From a practical perspective, get your documents looking good. Get your CV. If you need someone, get a professional graphic designer person. It's not a big expense. There are people out there. So first of all, come in hot with your CV. Be prepared. And I think, again, with that, I really put stock in having a meeting with the people beforehand. And if you go in with confidence, hi, this is me. This is where I've trained. This is the website, if it's SARM or AFSA or whatever, conflict dynamic, whatever the place is. Go check out the website, see what they're all about if you want to see where I trained. But come in with confidence. This is me. I'm the mediator. This is my process. And even, it doesn't matter if you've been mediating for 20 years or 2 years or 6 months. I've done the training. I'm ready to assist you. And sometimes I find in the pre-mediation, put the ball in their court. Say to them, what do you understand mediation to be? And the minute you put the ball in the attorney's court and ask an attorney a question, they love to give you an answer. That's where, so you've got to, everything's got, and I hate, it's a very general statement, but in our profession, a lot of it is what you look like, how you present, how you come in. Attorneys work on perception. So have your letterhead, have your CV, come in with confidence, and there's nothing to be unconfident about, because they're relying on you. Remember, without you, they can't get a trial date in the Gauteng area. So you actually do have a seat of power as a mediator. Before, we were kind of like the evil stepchild of process, because we were just kind of there, and it was a soft and squishy science and soft and fluffy, and everybody's holding hands. But now we're a need, not a want. And there are consequences. Mediators need to be more confident in their perception of who they are and where they fit into the process. And outside of Gauteng, people you because they want to resolve something. If you've got both parties coming to you, they want you there. So you do need to take the reins, and you are taking. That's why I use metaphors in my presentation of the captain of the ship, the coach, you're running the playbook, because that's who you are. And I think, but as I say, from a practical perspective, make your CV look good, come in with confidence, and put the ball in their court, and then run the process. That's my advice.
Love it. Thank you so much, Barbara. Corin, what are your thoughts?
Yes, thank you, Barbara, for that. I agree 100%. I think it is also important for mediators to make sure that whatever training they intend to do is accredited training. That's very important. Mediators also need to make sure that they are certified with the necessary bodies. If you want to do family mediation, you need to be a NAPFAM certified mediator. If you want to do civil, commercial, or RAV, or any of those, you need to be DISEC accredited. So it is very important that you tick all the boxes as a mediator, that there's no questions surrounding your training and validity of your accreditation. Make sure that your certifications are up to date and that you've got the newest ones. So if it is asked, then you can immediately present it, that you're not scurrying around trying to find your certificates and that they're out of date. A positive thing about mediators is, with all the training we do receive and we do undergo, we are trained to control emotions. We are trained to control emotions in the room, because a lot of attorneys say, yeah, but we've got very high conflict parties. They don't want to be in the same room together. How are you going to control the room? How are you going to control the emotions? Mediators are trained to do that. And we do it very well. And I want attorneys to buy into the process and not be scared about the process, and to give mediators the benefit of the doubt that, go and experience it, speak to a trained mediator, get some information. What I talked about, find out exactly what mediation is. And then, maybe then review your view on the whole process and what mediators do, because mediators, we are, first of all, very people-orientated people ourselves. And, we are solution-focused, and we help people communicate. Teresa always uses the example that, if one party speaks Excel and the other one Word, we're the translator that could help people find, understand each other. We speak both languages. We simplify issues for people so that they themselves can come to a solution. And I want attorneys to realize that mediators are trained professionals as well.
Fantastic. Teresa, you guys are in community of property for time's sake. Would you like to add anything to WorkWife, or
quickly? I'm speaking to the mediators, so attorneys, please block your ears. The dark psychology is, no one proposes marriage on the first date. Build a relationship. Build a relationship. See who the attorneys in your area are. Remember, ask yourself, what would the attorney want? They were talking about how you present yourself, your accreditation, that all your training certificates are up to date, because attorneys like accountability. They don't want to look like idiots in front of their clients. They want to know you. They want to get to know you. A little bit of dark psychology. Ask them for a favor. Ask them legal advice. Hey, Mervyn, that one worked with you. I just never went away. Okay. So what I want to say to you is, build your tribe. It's more important that you build relationships than trying to put yourself out there as a mediator of a jack of all trades, and I'm open for business and now nobody's hiring me. Go find your business. Go find your people. That's all I wanted to say.
Love it. Thank you, Teresa. Yeah, no, absolutely. I always love jokes at my expense. It's great. Um, I agree with what all of you say. I think I would like to add just two things to it, and I just had this little light bulb moment as you were talking, Teresa. Stay in your lane, folks. One of the biggest objections that we have against mediators, and we have to acknowledge it, is mediators that are not adequately trained for specific um, subject matter, attempting that subject matter. Figure out where you fit in and fit in there super well. For example, give me a family law matter, either as attorney or as mediator, and I know what I'm doing. I'm trained in that area. Give me an RAF matter, and I will bankrupt not only the RAF, but the parties and probably the LPC and my Fidelity Fund as well. I will not go near it. If it is subject matter that you do not understand, stay away from it. That is one of the chief objections that I've seen as an attorney. And I think the best way to ameliorate that risk is to stay in your lane. And secondly, make friends. The trick about networking is not to go and set up a meeting with someone with the intention of, I want to ask them for something. Go have a cup of coffee. Go have a cup of coffee, genuinely be interested, and synergy happens. Right. That being said, I take it Barbara, Teresa, and Karen, all three of you are volunteering yourselves for cups of coffees with all of our mediators and attorneys who are in. Fantastic. I will divvy out your
As long as it's
email
good coffee.
addresses. Oh, absolutely. Absolutely. Very, very interesting comments coming through. Joe saying that we must maybe call the pre-mediation meeting an information meeting rather than selling it as a done deal. I tend to agree.
I
The
like
protocol sells it as a as a pre-mediation, and it really limits it. It says only if someone has an issue with the process, but I think that's really taking a lot of the benefit away from it. Being able to assist attorneys through understanding the mediation process. This is new ground for all of us, folks, for all of us. I
Absolutely.
know of not one mediator that has done a lot of 41 Cap A work who I don't know for a fact has either sought advice on ThinkLegal or privately or on a phone call or whatever. I see it coming through. We are all figuring it out. Controversially, I might get shot for saying this, but even the RMOs are figuring it out.
Damn, and I was going to
Surprise.
say, approach your RMO, use your RMO,
No,
hold them accountable.
the RMOs are working their fingers to the
Yes.
bone at this stage to get compliant with the protocol. I think it really came kind of out of nowhere for everyone. So we're all figuring it out together, and we all need to be patient and understanding with one another. But yeah, great point, Joe. Salome says, Prof. Iman Vogel says, just for interest's sake, in psychology, when talking about clients' readiness for a change, it's important to identify whether they're in the pre-contemplation, contemplation, action, or maintenance phases, so you can match your therapeutic strategy to their readiness for change. I think that's especially in the family law sphere, that's something that's major that we need to understand, and that's where mediators are trained and should be trained. Teresa, can I see you've got your hand up. You can jump in with this. I'm getting excited.
I want to reiterate that we need to stay in our lane. And as a mediator, you do not assess people. So be careful of that, because we all have a background. We all have training where we come from. But it is very dangerous to just apply. Let's say Mervyn is an attorney. He cannot walk into mediation and just all of a sudden start giving legal opinions and quoting the law and whatever, because that's not mediation. I have a coaching background. I have a financial background. I can't walk into mediation and just say, listen, I've got all of these qualifications. I know exactly what's going to happen here. So it is very valuable to have all of these knowledge that we've been given in our previous lives. But we need to, as mediators, be very careful, because like you say, in psychology, there's an assessment. But For us as mediators, we have to mediate the parties in front of us and rather try and control the situation that we have in front of us.
It's a very interesting point, Teresa. And I think if I look at Salome's comment there, I think very much part of getting the to where the parties are at in front of you is to understand where they are in the process. I know a lot when I speak to mediators, one of the things that will be said is he's not ready yet. Hart is nog te seer. He doesn't want the divorce. Barbara, what are your thoughts on that?
I think because Salome's comment just, it's identify. She doesn't really say assess. I think, you can identify, and it's sorry, I'm not. Again, personal disclaimer.
Yes.
I know where her offices are, Teresa. Don't worry.
Teresa's got my number. What do you mean?
Yes. All of them.
So I think, yes, but the identifying where they are, like you say, you're never going to get people. I mean, there's at the master classes at the social justice conference, there was one on where the neutrality. You're never going to get the textbook case where everybody's in and the playing field is leveled and this person will let this one talk. But that's where you, as the mediator, comes in, and you are going to identify where they are in their phases. And helpful tools are like, putting the goals on your whiteboard or your flip chart or whatever instrument you use. I'm still old school. I use my flip chart with my newspaper and I put the goals on the top. But it's all about trying to bring those people into a space where they might actually converge. They might not necessarily meet, but they're going to converge.
Yeah. It's interesting the tools that you can use. I know Teresa and Karen have their whiteboard, and when we were contemplating where and how the offices were going to look, like one of the first things that they campaigned for is the table must be round and there must be a whiteboard, and there is just no negotiation. I was like, what about windows or ventilation? But they got their whiteboard. In any event, Simon Gile says it's very reassuring to get attorneys involved. I've noticed most of them give the paralegal the duty to partake in the mediation process on their behalf. Make no mistake, there are some paralegals who are very qualified. I know a lot of paralegals have done their mediation training where the attorneys might not have had the training, but very, very interesting point. Carmen asks, which body regulates mediators? Now, this is a bit of it's an interesting question because there is no statutory body as yet. The bodies that are in existence are formal bodies, well-regulated bodies, but they are not created in terms of statute. For example, you will hear various themes come up. You will hear NABFAM is family law, DISAC. You will hear IMI, you will hear CEDAW, and then you will also hear of some universities that also back mediation processes. And then under those overarching bodies, and I'm sorry if I missed one, I'm going off the top of my head, you have the recognized mediation organizations, and that is where various different bodies come in. So under NABFAM, you have 4 constituent bodies: Social Justice, SARM, KZN Society of Mediators, and FAMAC. And the last 2 are regionally bound. Under DISAC, I know you have, I believe Conflict Dynamics is under DISAC. Under one of the universities, you have MSSA under, I think it's University of the Orange Free State. So do yourself a favor, Carmen, go and have a look at the protocol, no, the directive, not the protocol, the June 2025 one. There is an annexure of which are the recognized mediation organizations. If you want to mediate under the protocol, you must be a member of one of the RMOs in good standing. So go and have a look at that. Very interesting question. I'd love to go through this one. Challenging question. Hadia raises it. Working in law firms, I've seen cases where clients are advised to attempt mediation, but not to ultimately waive any of their claims or rights. What role can a mediator play, or what can a mediator do in these situations? Now, I think I'm going to give it to each of our panel members. If you guys can do it quite briefly, we've only got 6 minutes left. I think let's stay away from the delinquency provisions. We know about the delinquency provisions. The lawyers can get involved and they can go and pits one another in court. But as a mediator, what are some of the tools that one can do to get past these deadlocks? Corin, can I start with you perhaps? Are you comfy? Or do you want to hear what the other two have to say first?
I think let's start with Teresa with this one.
Yeah.
I can see she got very excited when I mentioned this.
I saw that.
Yes, I feel quite passionate because I have been used what we in as mediators call the tick box lawyers. So they will send you the client for mediation, but I had one quite literally tell me that his attorney said to him he must sit here for an hour and a half. And after an hour and a half, he literally jumped up in the middle of my sentence and said to me, "I'm withdrawing." And he ran out screeching tires in the parking lot. I know that the protocol makes provision in the mediators report these days for certain disclosures that you can make as a mediator in terms of bona fide, malafide. So if someone really didn't attend a mediation in good faith, there's a lot of debate in our industry in terms of how many disclosures we have to make as mediators where the confidentiality is still protected. I feel quite strongly that if something like that, like this guy who literally told me his attorney said, okay, where something like that happens, I would be comfortable to indicate a malafide attorney, but it is still very difficult because we have to be very mindful as mediators that we protect the confidentiality of the process. So I'm rather going to answer it like this. If I have them in front of me in a mediation, I am going to mediate my heart out, and I will do my utmost best as a mediator, even if their attorneys were not in a bona fide way sent them there. I would still try to appeal to the parties in terms of the benefits of potential settlement, because I have tools to my that I can use, like BATNA and WATNA. So that's my answer.
Fantastic. Barbara.
First of all, I'd say to the client, I question the client what they understand about waiving their claims or rights, because reminding them that mediation is actually without prejudice and non-binding.
Correct.
And that by that very nature. So ask them what they understand by that, because there might be an understand, or they're saying something that they don't quite, they've taken it like that and understand. And then also use your caucusing, use your caucus provisions, caucus with the attorney and his client. And say to them, okay, why was this instruction given? What do you guys understand? Because it might be just a breakdown in communication, or you've got an attorney, or again, you already have an actual malafides obstructive, human being, then the delinquent provisions will prevail. But it might just be an understanding and a communication issue. And I mean, I battle with caucusing. I really I always find like it affects my neutrality. So that's a personal thing that I need to work with. But in this case, I would use the caucusing provision.
100%. I think it's easy to say negotiate and compromise on nothing until you're sitting in the room. Why do most matters settle on the steps of the court? Well, the one part is the threat of an impending judgment, but the other big part of it, you actually have to now face the enemy. This person is no longer demonized. They're not some evil force living 5 blocks away who drops off the kids every 2 weeks and who you scowl at through the window. Now it's a person sitting in front of you. Now it's another human being who you at some point had to deal with. And I'm talking about family law. Once again, that's my lane. But I think that is an element. Chiama says, one thing that I always put to my clients as an attorney is to consider what they're willing to let go, what they're willing to compromise, and what are their non-negotiables. I think that's very, very important for framing and posturing for clients beforehand. And I think it's a very good example of an important role that clients can utilize their attorneys for, an important role that attorneys can play in mediation. I think it's beautiful that we have all of these different people working on a problem. Don't you folks also think that it's just hubris to think in the old days that people would go and find one person with one skill set and say to them, sort out something as complex as a family. Once again, very strong family law bias, but it really is such an ecosystem, and we need to start realizing that. Then another common ask: as an attorney, do you have to be part of NABFAM and the Law Society? If you are a practicing attorney, so Karen is a good example. Karen was for a while on the non-practicing role, where she was only a mediator, not working within a law firm. Now she is working as a mediator within a law firm, so now she has to be on the practicing role of the LPC as well. And then you have the dual kind of requirements, and you make sure that all of your insurance is paid, and then you sleep well at night. Hey, Barbara, it's double trouble, both sides. Okay, we've got a comment regarding ADR PSA. I think we're all very, very excited about ADR PSA coming in for some standardization. I can't wait for that to
me
be
too.
there. And I think most of the industry has bought into the idea of ADR PSA. So thank you so much for Ishara for raising that. Let me quickly go through and see if we've got any. What other questions do we have?
Salome said she's coming after all of us for coffee. Come for it. Yeah, we
I
are
expect
open.
it.
Bring
Yeah,
it.
absolutely. Absolutely.
Salome,
Right.
you're welcome.
Great. So we've got 1 minute over. So just before I end off the event, I'm going to quickly just remind all of you of the following. One, if you're not a part of the ThinkLegal WhatsApp groups, please do come and join us. Go to thinklegal.coza, jump on the groups, chat to us. Number two, 14th of November, save the date. If you want coffee with all of these lovely ladies, and perhaps even with myself, not that I'm a lovely lady, then please join us. It's a good opportunity. MV Cafe in Northcliffe. We're going to be doing a lovely event there. I'm looking forward to it. If you are involved with one of the RMOs or any organizations and you would like to get involved with that, please get in touch with myself, Teresa, or Corin, so that we can make sure that you can get involved with that. Number three, those of you who want to look at my full trainings, the CPD trainings on the protocol and 41 Cap A's, please go and have a look at thinklegal.coza. And then finally, from my side, a special thank you to Barbara, to Corin, and to Teresa for their time and their insights. This has been phenomenally useful to me personally, and I trust all of you as well. We are getting such beautiful messages in the chat box for you guys. So well done. I really thoroughly enjoyed it. And the number of people that took 2 hours on a Friday morning to sit in with us really also shows that it was a wonderful, wonderful session. Guys, I will be distributing Corin, Teresa, and Barbara's websites and their emails to everyone who attended. Although it was said tongue-in-cheek, I have very rarely met three people as generous with their time to assist colleagues and to network with colleagues. So please, I do encourage all of you to get in touch with them and really, truly have a cup of coffee with a colleague and see how we can all work together as an ecosystem. So I'm going to be ending the event in a minute or two. Thank you in closing to all of you who took the time to be with us today. It was really lovely having you. Thank you for all the wonderful interaction from all of the professionals, from attorneys, advocates, mediators, mental health professionals, even some candidate attorneys. Wonderful to have all of you here. Thank you very much. Have a wonderful weekend. We will see you at the next webinars. Details will be communicated early next week. So from Corin, Teresa, Barbara, and me, we'll see you at the next one, and goodbye.
Bye.
Bye.
And